Welcome back to the deep dive. Lay back, listen, and learn as we hit the final stretch of our civil procedure journey today.
That's right.
If you've been navigating this landscape with us, you've seen how a case kicks off the filing, jurisdiction, pleadings, discovery, all that groundwork.
And today, we really arrive at the end game. We're digging into the rules that dictate how a lawsuit actually concludes.
Right, and how those conclusions can, or sometimes can't, be challenged.
Exactly.
Right?
And also making sure the case was, brought in the right geographic spot to begin with.
Absolutely. We've got your source material laid out, focusing on these really critical late-stage concepts: preclusion, appeals, venue and transfers, and that big one for federal courts, the Erie Doctrine.
Yeah, our mission here is basically to pull out the key insights from these sources for you. Think of it as understanding the rules that answer those big questions.
Like, is this really over?
Can I sue again? How do I fight the court's decision? And like I said, was this case even filed in the right courthouse?
Okay, let's unpack this. First up, these doctrines of finality. The rules that basically say, nope, no do-overs here. We're talking about preclusion.
Right, preclusion. It covers both res judicata and collateral estoppel. And fundamentally, it's all about, well, efficiency and fairness in the system.
Efficiency and fairness. How so?
Well, the core idea is that once something's been properly fought over and decided, the parties or folks closely connected to them shouldn't have to drag everyone through the mud again.
Makes sense. And the absolute starting point, the foundation for any kind of preclusion, according to the material.
Yes. You have to have an earlier lawsuit that ended with what's called a valid final judgment on the merits.
Okay, valid final judgment on the merits. That sounds like lawyer speak.
It is, but it's crucial. It's the non-negotiable first step. If that first case didn't actually resolve the substance of the fight, the merits, then preclusion usually isn't going to stick.
Got it. So let's dive into the first type, claim preclusion. The sources call it res judicata, and the ultimate one-two punch.
Yeah, it's powerful stuff. Because it prevents someone from relitigating an entire claim. Not just a piece of it, the whole thing.
The whole claim.
The whole claim. It kicks in if the claim was or could have been litigated between the same folks in that earlier case, the one that ended with that valid final judgment on the merits.
I like the metaphor they used. You can't slice up lawsuits into episodes like a Netflix series.
Exactly. If you got one set of facts, like a car crash, that gives rise to, say, property damage and personal injury claims.
You got to bring them all at once.
Generally, yes. Bring them in that first lawsuit, or you probably lose the chance to bring the other ones later.
Okay. So what are the key requirements the notes lay out for claim preclusion?
All right. First, same parties. Were those in privity?
Yeah.
Pretty straightforward. The identical people or companies from the first lawsuit.
Or someone legally standing in their shoes, right? Like an executor.
Precisely. Or maybe
Okay.
a company that bought the first company. That's privity.
Okay. Then there's that phrase again. Final judgment on the merits. This feels like a potential trap. What is a judgment on the merits?
Right. So the sources say it typically follows a real decision on the substance.
Yeah.
Think, a judgment after a full trial.
Makes sense.
Or a grant of summary judgment. Even some dismissals, like a Rule 12b-6, dismissal for failure to state a claim.
Wait, why 12b-6? That's early.
Because the court is saying, even if everything you allege is true, you still don't have a legal case. It's a ruling on the legal sufficiency, the merits of the claim itself.
Okay, I see. So what's generally not on the merits then?
Usually procedural dismissals. Like if the case gets tossed for lack of subject matter jurisdiction.
The court didn't have power.
Right. Or improper venue, or failing to join the required party. The court didn't actually get to the substance of the plaintiff's claim in those situations.
And settlements.
Generally, no. A settlement is usually a contract between the parties to end the case, not the court deciding the merits. Now, if the settlement gets formally incorporated into a court judgment on the merits, that's different. But typically, a standard dismissal based on settlement isn't preclusive on the merits.
That distinction is vital. Okay, requirement 3. Same claim, often using the transactional test.
Yeah, the transactional test. It asks, does the claim in lawsuit number 2 spring from the same set of facts or the same transaction or occurrence as the claim in lawsuit number 1? It's all about the underlying events.
So back to the car accident. I sue for my crumpled fender first, then later my back starts hurting, and I try to sue for personal injury from the same accident.
Claim preclusion would likely bar that second suit. Both claims arose from the same transaction, the accident.
It's that one bite at the apple idea.
Exactly. You had your chance.
Yeah.
You can't relitigate what could have been raised, even if you didn't raise it the first time around.
And the outcome of that first case matters, right? Merger and bar.
Absolutely. If the plaintiff wins the first case, the claim merges into the judgment. They can't sue again on the claim. They just enforce the judgment they won.
And if they lose?
If they lose, they're barred from trying again with that same claim. It provides real closure, finality.
Okay, makes sense. Now let's pivot to issue preclusion or collateral estoppel. This one feels different, more targeted.
It is definitely more targeted.
Yeah.
Issue preclusion stops the relitigation of a specific issue, not the whole claim, just one particular point.
An issue that was actually litigated and decided.
Yes, and was essential to the judgment in that first case, even if the overall claims are different in the second lawsuit, or maybe even the parties are different sometimes.
If that specific point was already settled, it stays settled.
That's the core idea. Like, look,
Yeah.
you already fought this exact point out. You had your day in court on this issue. We're not doing it again.
So the requirements must be a bit different then. Still need that final judgment on the merits from case one, I assume.
Still need that. But instead of same claim, you need the same issue, actually litigated and determined.
And actually litigated means it was really disputed and ruled on, not just lurking in the background.
Correct. It can't be something that could have been raised but wasn't. It has to have been actively contested and decided by the judge or jury.
Okay. And then this essential to the judgment part, that sounds critical.
It really is. The sources emphasize this. The decision on that specific issue must have been necessary for the court to reach its final conclusion in the first case.
So give me an example.
Okay. Say in a negligence case, the jury finds the defendant was negligent, but also finds the plaintiff suffered zero damages. The final judgment is for the defendant based on zero damages.
Right.
That finding of negligence, was it truly essential to the judgment for the defendant? Probably not, because the zero damages finding alone supported the judgment.
So the negligence finding might not be precluded in a later suit because it wasn't necessary for the outcome.
Exactly. It has to be a linchpin of the first decision. And the last traditional requirement. It's generally used by or against someone who was a party or in privity to the first suit.
Meaning it works against someone who had their chance to fight that issue?
A full and fair opportunity to litigate it, yes.
But then there's this curveball, non-mutual issue preclusion. That sounds complicated.
It can be. It means issue preclusion is being used by or against someone who wasn't in the first lawsuit at all.
And courts allow that sometimes.
They do, especially in federal court, but
Yeah.
carefully. It's about efficiency again, avoiding rehashing the same issue over and over. But fairness is a major concern.
Okay, I see two flavors mentioned, defensive and offensive. Defensive is a new defendant using it against the plaintiff.
Right. A new defendant in case 2 uses an issue that the plaintiff already lost on in case 1. The sources say this is generally looked on more favorably.
Why is that?
Well, imagine plaintiff sues manufacturer A for a defective product design and loses the jury, says no defect. Then plaintiff turns around and sues manufacturer B for the exact same alleged design defect in the same product model.
Defensive non-mutual estoppel would let manufacturer B say, hey, the no defect issue is already decided against you, plaintiff?
Precisely. It stops the plaintiff from just suing defendant after defendant, hoping for a different outcome on the same issue.
Okay. And offensive non-mutual, that's a new plaintiff using an issue against the defendant.
Yeah, a new plaintiff in case 2 tries to use an issue that the defendant lost on against a different plaintiff back in case 1.
So the defendant was found liable on issue X in the first case, and now a new plaintiff wants to use that finding against the same defendant.
Correct. This one is viewed more cautiously by courts. It's generally disfavored compared to defensive use, but it is allowed sometimes if it's fair.
What makes it fair or unfair?
Courts look at things like, could the new plaintiff have easily joined the first lawsuit? They don't want to encourage plaintiffs to just sit back and wait.
The wait-and-see problem.
Exactly.
Oh.
Also, did the defendant have a real incentive to fight hard on that issue the first time? Maybe the first case was for tiny damages, so they didn't go all out. And are there inconsistent judgments out there? If the defendant won on that issue against other plaintiffs, it's less fair to let a new plaintiff use the one loss against them.
Wow. Lots of factors. The sources definitely flag the common traps here, mixing up claim versus issue preclusion, and especially getting tripped up on what counts as that final judgment on the merits.
Absolutely. Nailing down those distinctions is fundamental. These doctrines really shape the landscape of finality.
Okay, so moving on from preventing relitigation,
Right.
sometimes you can challenge the outcome. Through appeals, this is the not over till it's over part, but with lots of rules.
Oh, definitely lots of rules. The appeals process is how you ask a higher court to review what the trial court did. But, and this is a big but.
You can't just appeal every little thing you don't like as it happens.
Exactly. That brings us to the final judgment rule. Generally, you can only appeal after a final judgment is entered. The case has to be, as the sources say, done at the trial court level.
Nothing left for the judge to do but, like, sign off.
Pretty much. Execute the judgment. The idea is to stop constant interruptions, these piecemeal appeals of every single ruling.
Imagine the chaos if you could appeal every discovery dispute.
Litigation would never end. So things like denying summary judgment or ordering a new trial or most discovery orders, those aren't final judgments. You usually can't appeal them right away.
But there are exceptions, right? Ways to appeal before the case is totally finished.
Yes. Interlocutory appeals.
Yes.
Certain types of orders get a fast pass to the appellate court.
Like what? The sources mention orders about injunctions.
Yes, orders granting or denying injunctions are a classic example because they have immediate real-world consequences.
Also, decisions on class action certification, whether to allow the case to proceed as a class action.
Right. Certifying or denying class status is often immediately appealable too. Huge practical impact.
And sometimes the trial judge can basically greenlight an early appeal.
Yeah, under specific statutes, the district judge can certify an order for immediate appeal if it involves a really important disputed legal question. And appealing now could actually speed up the whole case.
And then there's the collateral order doctrine. What's that about?
Okay, this one's a bit tricky. It's for orders that are kind of separate from the main lawsuit's merits.
Like a side issue.
Sort of. It has to conclusively decide an important issue that's separate from the merits, and it has to be something that would be effectively unreviewable if you had to wait until the very end.
Like qualified immunity for a government official. If they're immune, the point is to avoid trial, right?
Exactly. Waiting until after trial to appeal the denial of immunity would defeat the whole purpose. That's a classic collateral order.
Okay, so you figure out if you can appeal. Then there's timing. The sources stress this. The deadline.
Crucial. Absolutely critical. You typically have just 30 days from the entry of the final judgment to file your notice of appeal.
30 days? That's not long. And the consequence if you miss it.
Missing this deadline means you're out. Seriously. The appellate court generally loses jurisdiction. It's usually a fatal error.
Ouch. Okay, so you file on time, your appeal goes up. The appellate court doesn't just retry the case, does it? They use standards of review.
That's right. They don't rehear witnesses or take new evidence. They review the trial court's decisions based on specific standards, depending on what kind of decision they're reviewing.
Gotcha. So for pure legal questions, did the judge apply the right law?
That's de novo review, means from the new. The appellate court looks at the legal issue with completely fresh eyes. Zero deference to the trial judge's legal conclusion.
Okay, best chance for reversal there, maybe?
Often, yeah. If it's a pure legal error. Now, for factual findings made by the judge, like after a bench trial, the standard is clear error. This shows a lot of deference. The appellate court will only reverse if they're left with a definite and firm conviction that a mistake has been committed. It's tough.
Because the trial judge actually saw the witnesses, heard the evidence.
Exactly. They were there. And for discretionary calls by the judge, like decisions on admitting evidence or managing discovery.
That's abuse of discretion, right? And the sources say this is the toughest to reverse.
It often is. You have to show the trial judge's decision wasn't just wrong, but was unreasonable, arbitrary, or based on a legal mistake, or clearly wrong facts. It's a very high bar.
So strategically, when you're appealing, you really need to know which standard applies to each issue you're raising.
Absolutely. It shapes your whole argument and your odds of success.
Okay, shifting gears one more time. Before finality, before appeals, even before the merits sometimes, the case has to be in the right place. Venue, the proper geographic location.
Yeah, and let's be super clear. Venue is not the same as jurisdiction.
Right. Jurisdiction is about the court's basic power over the subject, SMJ, power over the people, PJ.
Venue assumes jurisdiction exists. It's about which specific courthouse, which geographic district within that system is the right or most convenient place for the trial.
So a federal court in California might have jurisdiction over a case involving parties from New York and Florida.
If PJ and SMJ are met, yes.
But California might still be the wrong venue.
Could be. depending on the venue rules.
Yeah.
Venue tells you which federal district court is appropriate.
So what are the general rules for proper venue in federal court, according to the sources?
Okay, rule 1, you can usually lay venue where any defendant resides if all defendants reside in the same state. Makes sense, right? Convenient for the defendant.
Yep.
Or where a substantial part of the events occurred, or where the property involved is located. This is often a key one. Where did the thing actually happen?
Okay, and if neither of those works?
There's a fallback. Any district where any defendant is subject to the court's personal jurisdiction when the case is filed. This is less common, used when the first two don't apply.
How does this work for corporations? Where do they reside for venue?
Good question. For venue, a corporation resides in any district where it's subject to personal jurisdiction when the suit is filed.
Right.
And if a state has multiple districts, you then narrow it down.
Right.
The corporation resides in any district within that state where its contacts would be enough for PJ if that district were its own state. It could be complex.
And the big don't from the material? Venue is not based on where the plaintiff lives.
Correct. Common mistake. Focuses on the defendants and the events.
So what if you do file in a district where venue is technically proper, but honestly, another district would be way more convenient? Witnesses are there, evidence is there.
That's where a transfer of venue under Section 1404 comes in. The court where you filed the proper venue can transfer the case to another federal district where it also could have been brought originally.
If it's more convenient.
Right. For the convenience of parties and witnesses, in the interest of justice. It's moving from a proper place to a better proper place.
But what if you messed up and filed where venue was improper to begin with?
That's Section 1406. If the original venue is improper, the court has a choice. Either transfer or dismiss.
Transfer it to a proper district or just kick the case out.
Exactly. Transfer to fix the mistake or dismiss and make the plaintiff refile correctly.
So 1404 is convenience transfer from a proper venue. 1406 is fixing an improper venue choice.
You got it. Key distinction.
And one last concept here. Forum non conveniens. Sounds like inconvenient forum. Is it like a transfer?
Sort of, but crucially different. Forum non conveniens allows a court, usually federal, to dismiss a case entirely because a court in another country is clearly the better place for it.
Oh, so it's about international cases. Sending it abroad.
That's the main use, yes. Federal courts can't transfer abroad to a foreign court system. So if the truly appropriate forum is, say, in France.
They just dismiss the U.S. case.
Right. They dismiss it, assuming the foreign forum is adequate, meaning the plaintiff can get some kind of remedy there, and the balance of public and private factors heavily favors the foreign court. It's a high bar, too.
Okay, one final major topic before we wrap up this endgame tour. The Erie Doctrine. This sounds foundational for federal courts.
It absolutely is, especially in diversity cases, those cases in federal court only because the parties are from different states, but the underlying claims are based on state law.
Right. So what's the rule?
The core Erie rule, based on the landmark case, Erie Railroad v. Tompkins, is that in diversity cases, federal courts must apply state substantive law and federal procedural law.
State substance, federal procedure. Why?
Well, the underlying idea is that federal courts shouldn't invent their own federal common law for issues that states normally govern, like torts or contracts. The outcome of a state law claim shouldn't dramatically change just because you happen to file in federal court instead of state court across the street.
So you can't just pick federal court to get a different substantive result.
Exactly. The goal is to prevent forum shopping based on different substantive rules and ensure that state law governs state rights and obligations, even when enforced in a federal courthouse. The federal court uses its own procedural rules, like the federal rules of civil procedure, but the underlying legal rights come from the state.
Wow. Okay. So we've really gone from the very beginning, filing that complaint, all the way through to finality, appeals, venue, the whole life cycle.
It really is a strategic roadmap, isn't it, when you see it all laid out? Understanding preclusion tells you when you can, or more likely cannot, sue again.
Appeals tell you when it's game over at trial and how hard it is to challenge that.
And venue tells you where you should have been geographically in the first place.
The sources summed it up well. Know the terrain, use the tools, and pick your battles. That's the Civ Pro game.
And seeing these endgame rules really hammers home how critical those early choices are.
Absolutely. Which, brings us to a final thought for you, the listener, to chew on. Considering how powerful preclusion is, how final judgments generally are, and how strict the rules for appeals and timing are, How does all that intense finality shape the really critical strategic calls that lawyers and parties have to make from day one, from the very instant they start thinking about filing a lawsuit?
Yeah, it definitely puts immense pressure on getting everything right the first time. Knowing there might not be a second chance on that claim or even on that specific issue, it forces careful planning.
Food for thought indeed. Well, thank you for joining us for this deep dive into the civil procedure endgame. Hope you could lay back, listen, and learn.
Always great exploring these crucial concepts.
We'll catch you on the next one.